let's talk about standing for just a moment. We're going to talk about standing. The legal right to initiate a lawsuit. All right? Proper standing. To do so, a man or woman must be sufficiently excuse me. Standing. The legal right to initiate a lawsuit. All right? The proper way of bringing a lawsuit. Okay? To do so, a person, a man or a woman, must be sufficiently affected by the matter at hand, and there must be a case or controversy that can be resolved by legal action. All right? Remember, suits can only be brought against like entities. So, corporation against corporation, man versus man, or man versus woman, woman versus man, vice versa. But man can't sue a corporation, and corporation can't sue a man. The suits must be brought by like entities. All right? So, there are 3 requirements for Article 3 standing. We're talking about an actual court of record. Okay? An Article 3 court, subsection 2. Could even qualify as a subsection 1. Subsection 1, if you want to get in the Article 3, subsection 2, subpart 1, qualified venue, before a chancellor, you need to plead the, there's very specific wording, the controversy between the rules of equity and the rules of law. Okay? Now, how would you get into an Article 1, Section 2, or Article 3, subsection 2, subpart 1 venue? The conflict of variance between the rules of equity and the rules of law pertaining to property. Okay? Property can be tangible and intangible. It's important. That was a hard one for me to grasp. Intangible property. My buddy's like, yeah, your rights, you can't touch them, taste them, smell them, feel them, nothing. But they're there. So they're intangible. Okay? To a degree. So, Article 3, standing. 1, injury in fact. Okay? You must be able to affirm with first-hand perfected knowledge that you have sustained harm, damage, or loss. I don't like the word injury. Injury is a legal term. Okay? If you're going into equity, you're not going to want to use the word injury. You're going to want to use harm, damage, and loss. Okay? Harm, damage, and loss. You will never find a personal harm lawyer, a personal loss lawyer, a personal damage lawyer. You will, however, find throughout the legal society all kinds of injury lawyers, okay? So, with that said, you must have the harm, damage, or loss in fact, or an injury, which means an invasion of a legally protected interest, that is, A, concrete or particularized, and B, actual or imminent, okay? Not conjectural or hypothetical. Meaning, you can't say that I don't believe the guy is going to actually fulfill his end of the agreement, and thus I'm going to go ahead and bring suit because I know come Friday that guy isn't going to fulfill his obligation. You can't bring a suit hypothetically or with conjecture, okay, hyperbole. You won't have proper standing. The suit will be dismissed for a frivolous claim for which relief cannot be granted, and then you open yourself up to being liable for slander, defamation, and a litany of other things. Okay? So you don't have proper standing prior to something happening. 2, a casual relationship between the injury and the challenged conduct, which means that the injury fairly can be traced to the challenged action of the defendant, of the man or woman. Okay? I don't like the term defendant and plaintiff. I kind of despise them on a cellular level. I like wrongdoer and claimant, okay? Or claimant and respondent. Those are much better suited for the causes of actions that I make because I don't file fucking complaints. Who cares about a complaint? That's a bunch of whining, nagging, bitching, moaning bullshit. Man make claim, corporations complain, all right? Don't care about complaints. If you're a man or a woman and you got reason to believe that you've been caused harm, damage, or loss by a wrongdoer, okay, then you make a claim. Men make claims, women make claims, corporations file complaints, and has not resulted from the independent action of some third party, not before the court. And 3, a likelihood that the injury will be redressed by a favorable decision, which means that the prospect of obtaining relief from the injury as a result of favorable ruling is not too speculative. Okay, meaning, in other words, you have the evidence, you have the contract, you have the video or the photos, and it's not too far of a stretch to believe that the ruling will be favorable to you. Okay, that's Lujan versus Defenders of Wildlife, 112 S period CT period 2130, 2136. This case was had in 1992, where the court took it upon itself to explain to one of the parties how it works. All right, pretty fucking cool. Now, I have a Supreme Court case, multiple Supreme Court cases, mind you, which are not case law, case precedent perhaps, but they're nothing more than an opinion based upon educated people who rendered an opinion that I really agree with, which states, in whole or in part, and I'm going to paraphrase because I don't have it before me at this particular moment in time, that the court, the judge sitting on the bench, must assist somebody who is a pro se litigant. Now, I'll never be a pro se litigant. Pro se is a bad word to me. It's like, ugh. It just screams liability, pro se litigant. But impropriety persona, sui juris, in one's own proper person, doing something correctly, I'll take that. And it states in whole or in part that the judge can't just merely dismiss your document based upon technicalities. They have to tell you what it is that's wrong with your motion, or what's wrong with your let's say it's quo warranto, or what's the next one? There's quo warranto, habeas corpus, there's memorandums, there's all kinds of different writs. But let's say that you file a habeas and it's wrong. Instead of ostracizing you, they can't just dismiss it saying that, it's not in proper form. Form is to be dismissed with somebody who is not a lawyer, okay, or an attorney, I should rather say. And they are to help you by giving directives. They don't help you write it. They just say, look, this is what needs to be exhibited in this document. They're going to be probably vague and ambiguous about it, but they're at least going to guide you in the right direction. And it's been upheld by multiple appellate courts and the Supreme Court, that when these lower courts make these rulings, and it's not beyond the preponderance of doubt that they have a valid claim, then they are to help the pro se litigant, or the man bringing a claim propria persona or sui juris. They're to help you instead of just dismissing your action. They're to tell you, hey, this is what we need to see. We need to see an affidavit in support of this motion. You can't just support a motion and hope that it goes through. You have to tell this court why this action should be granted, right? Give them the ability, because they can't bring things into the court that don't exist. All right, that's part of being a non-biased individual. They're not allowed to grab things that they know to be true and supplant them into your case in your favor. You have to show them the law, show them how it works, okay? All right. The law of void judgments and decisions. The Supreme Court decision on void orders. A judgment may not be rendered in violation of constitutional protections, okay? The validity of a judgment may be affected by a failure to give the constitutionally required due process notice and an opportunity to be heard. Earl versus McVeigh, 91 U.S. 503, 23 L period ED period 398. See also restatements, judgments 4B, Prather versus Lloyd, 86 Idaho 45 382. P2D 910. Limitations inherent in the requirements of due process and equal protection of the law extend to judicial as well as political branches of the government, so that a judgment may not be rendered in violation of those constitutional limitations and guarantees. Hansen versus Denkala, that's DENCKLA, 357 U.S. 235, 2 LED 2D, 1283 78S CT 1228. And with that, I will leave you guys be. I wanted to share that with you. I'm going to post the entirety of this document up above this video for you guys, all right? Because I just don't have the time to get to it all today. And I think it would be a great travesty not to share it with you guys who have the time to read, and maybe share it with your friends, your family, and your loved ones, okay? So with that said, thank you for all your support. Thanks for joining me, and I'm going to get back to work.